Good afternoon, everybody. Welcome to the Standing Committee on Access to Information, Privacy and Ethics. Meeting number 77, pursuant to order of reference Wednesday, September 27, 2017, Bill C-58, an act to amend the Access to Information Act and the Privacy Act and to make consequential amendments to other acts. Welcome. Right now we are at NDP 22. Mr. Cullen.
Just one moment, Chair.
Sure.
Oh, I thought we had PV 8 was our first up. Is it 22 or 21?
I have 22.
Okay. I just want to allow Ms. May a moment. Have we done PV 8 already?
Pretty sure.
Yeah? Okay. Just one moment, Chair.
Okay.
Yeah, so as you saw with the premise of many of our amendments to C-58, they're based on the testimony that we had, the witnesses that came forward and testified, particularly the Information Commissioner, who's most familiar with this act. One of the things that she brought forward in testimony was the need for an aspect of mediation. I'll quote her back on her November 1st testimony not so long ago. The reason why I'm recommending that there be a formal provision of mediation is because sometimes some complainants particularly do not wish to participate in the mediation process. I think that the mediation process is extremely helpful in resolving complaints in a more timely way. I think that would be helpful. It also puts focus on the mediation process with institutions as well. So resolving things through mediation seems to me, especially when there's a conflict between the applicant and the whatever ministry they're dealing with, is a way to make real the duty to assist aspect of current access to information law. If there's a duty to assist and there's a conflict of interpretation, then NDP 22, this amendment that we've moved forward under Section 13.1, would allow this. So a formal mediation function in the course of an investigation. That's essentially our amendment. I think it would help Canadians, and I think by way it would also help government in releasing information that's both helpful and appropriate, and that's our amendment.
Thank you, Mr. Cullen. And as your duty as chair, under the advisement of our legislative clerk, the amendment would allow the Information Commissioner to appoint a mediator for certain purposes. As House of Commons Procedure and Practice, 2nd edition states on pages 767, 768, since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge on the public treasury or if it extends the objects or purposes or relaxes the conditions and qualifications specified in the royal recommendation. In the opinion of the chair, the appointment of a mediator would impose a new charge on the public treasury. Therefore, I rule the amendment inadmissible.
If I could then add and appreciate the advice through you to the clerk then, that as the government has heard this advice from the Information Commissioner, and it's essentially a technicality that we're relying on to be unable to amend the bill this way because it may invoke spending later on, that if this is deemed a good thing for Canadians and a good thing by the Information Commissioner, then as the practice of C-58, if it were to become law, the implication and the use of a mediation would be at the purview of the government of the day. It doesn't have to be deemed in through act of law. So thank you for your reference, and we can move on.
Thank you, Mr. Cullen. And we'll move right on to shall Clause 14 carry. All in favor? All in favor?
Yeah.
All opposed? Carried. Shall Clause 15 carry? All in favor? All opposed? Clause 15 carries. We have Liberal number 5. I'm assuming Mr. Erskine-Smith.
The idea behind this amendment is there's currently
There's currently an exclusion from the Information Commissioner making an order in relation to an investigation that she commences. I've put this in more for discussion because, frankly, this wasn't flagged by the Information Commissioner. I had flagged it, and I had spoken to former Information and Privacy Commissioners at provincial levels who seem to have had order-making power in relation to investigations that commenced, but given it wasn't flagged by any of our witnesses, I had more just made this a discussion point and put it out there.
Thank you, Smith. Mr. Cullen.
Thank you. I think it's entirely appropriate. I'm wondering if, Nathaniel, you could explain through those other conversations, because I think we can learn a lot from other jurisdictions in terms of their application of sometimes very similar law. What might be an example of further order-making powers that would enable better, more clear information then be released to the public? If I can, through you, Chair, to Mr. Smith.
I mean, just very briefly, this is pretty narrow. The idea is where there's a complaint made under the Act as drafted, and rightfully so, the Information Commissioner can now make an order, but where she commences an investigation based on reasonable grounds and finds merit, she is precluded from making an order. Other Information and Privacy Commissioners at the provincial level do have the ability to make such an order, but as I say, this wasn't flagged here, so I don't want to dwell too long on it, but that's the explanation.
Any further debate? All in favor of Liberal number 5? All in favor? All opposed? The Liberal 5 is defeated. NDP number 24, Mr. Cullen.
Yeah, this goes at the heart of, because we heard, in a sense, conflicting testimony over order-making powers, interpretation of orders that are certifiable. We had, I believe it was Minister Bryson, suggest that all was well and that the powers were sufficient. But I'll quote our hardworking Information Commissioner again, Madame Legault, and from the same testimony I quoted earlier on November 1st. I think she was answering a question from Mr. Saini, who asked about this issue. She said, "That is not my interpretation of the bill as it is currently drafted. Essentially, if the government institution would basically sit on the order and not provide disclosure as being ordered to, what I would have to do is that I'd have to take a mandamus application in the federal court, which is part of the federal court legislation. But mandamus applications usually take around 18 months. That's my concern, and that's why I'm recommending that there be an added provision that I would be allowed to get the order certified in the federal court. I'm told by my general counsel here that those usually take 4 months for contempt of court proceedings." So in the issuing of an order and directing a department to come forward with information that's deemed to be vital and does not infringe on the privacy of Canadians, we've learned through testimony of the various groups, First Nations groups, civil society, journalists, that if information is delayed, information is denied. That the simple carrying forward and adding of months and sometimes years to the process, for some issues in particular, means that the public is never given satisfaction, because essentially the issue is now moved on. We're so many years beyond this. So the amendment that we've made in NDP 24 would follow the advice of the Information Commissioner to be explicit so that there's no interpretive wiggle room. It's simply the ability of the Commissioner to seek in federal court, which again, from her counsel's observation, would be in the 4-month range of delay, which is still a delay, but not a year and a half or more. From I'm thinking of some of the information examples we've been given, from residential schools and missing and murdered women to sexual harassment in the government, Ms. Doolittle's work out of the Globe and Mail, that part of the effort in revealing these important issues, and some of which the government has acted on, by the way, in terms of their recent legislation yesterday, the Murdered and Missing Inquiry, those are all based on the evidence that was gained from access to information, in which many cases it was delayed significantly because of this back and forth with the federal court. So all this does is clearly gives the Information Commissioner the tool that the Minister frankly said she already has, but the evidence is borne out differently in terms of the delay and this notion, not being a lawyer, I'm trying to be careful here of mandamus applications and the delay that seems to have been created.
Thank you, Mr. Cullen. Any debate?
I haven't made many mandamus applications, but I have made a few.
More than me.
Yeah, perhaps, yeah. And I shared a similar concern, but then the Information Commissioner did clarify in a recent letter, I think today, that the 18 months was not correct, and it's a much shorter period of time, still longer than the 4 months. And so I don't know that this is, it didn't seem as stark a problem from 4 months and 18 months. I think it was maybe 4 to 7 or something like that.
Mr. Cullen.
I suppose this would then be one of those amendments where you would look at it and say what harm might be caused by this. That if we even take, if the Information Commissioners Council now says it's not 18 months, it's 8 months, but we can reduce it through this. And again, this doesn't put any burden that we're aware of upon the federal bureaucracy in answering ATIP requests. This simply gives a clear path when there's some dispute about the information as to the path the Commissioner takes, which is a reliable 3 to 4 month delay. If this does that, which we believe it does from Council's interpretation, then, and it does no harm, then we would certainly see this as an amendment worthwhile, although I'm worried about the track record of voting so far. We'll see if worthiness is our only consideration here.
Elizabeth.
Yeah, thank you, Mr. Chair. I don't think you mentioned at the beginning of looking at the NDP amendment, but since mine is at Parti Vert 10, the Green Party 10, I think that if Mr. Cullen's motion is voted down, then my motion is voted down. So at this time, I'd just like to say why I put this motion forward. It is for the reasons that Nathan's just proposed, that the Information Commissioner asked for this section to be amended so that we could certify an order of the Information Commissioner as an order of the federal court, and I completely agree with the points that Nathan just made, that there's no harm that comes of this. It does allow us to ensure expeditious use of the Information Commissioner's decision, and there are a number of caveats in the way our identical amendments have been proposed. So if there's no harm of it, if there's no other good reason why the filing of the federal court would serve no useful purpose, we have enough conditions and caveats in this amendment to do no harm, but to potentially do quite a lot of good.
Yes, and just to clarify what Ms. May is saying, PB 10 cannot be moved after vote on NDP 24, and also overlap with Liberal 6. Liberal 6 cannot be moved if NDP 24 is adopted. That makes sense to anybody. So, hope it does. Ms. May's already spoken, so anybody else like to speak to this? Okay, we'll call the vote. All in favor of NDP 24? Yes. One thing to note too, please. I just would like a clear show of hands, so if you are supportive, raise your hand. If you're against, please, when the vote is called accordingly, raise your hand so we can make a better record of what your voting record is. So recorded vote, all in favor.
It's calling.
Oh yeah, calling, sorry. Yeah.
Okay, on NDP 24, yes or no, Mr. Bayliss?
No.
Mr. Dubourg? No. Mr. Erskine-Smith?
Yes.
Madame Fortier?
No.
Monsieur Picard?
No.
Mr. Saini?
No.
Monsieur Gourde? Yes. Mr. Kent?
Yes.
Mr. Cullen?
Yeah.
So NDP 24 is defeated. Therefore, we'll move past 10 and 6.
No, 6 we do it.
6.
We have 6. It was the, if it was only
If adopted, yes, correct. Yes, stand corrected. Liberal number 6, Mr. Erskine-Smith.
No, I mean, I'm not wasting the time of this committee. We've just had the discussion, and let's move on.
Okay. Any further discussion? All in favor of Liberal number 6? All in favor? All opposed? Liberal 6 is defeated.
we dealt with PV 11.
Since PV 11 and NDP 25 have already been dealt with previously, shall clause 16 carry? All in favor? All opposed? Clause 16 carries. Next, Liberal number 7.
Just moving that. Are we-
This is an amendment as follows. Section 3.1, the Information Commissioner may publish the report referred to in subsection 2. Then adding 3.2, however, the Information Commissioner is not to publish the report until the expiry of the periods to apply to the court for review of a matter that are referred to in section 41.
Thank you, Mr. Bayless. Just for clarity, this vote will also apply to the consequential amendment, Liberal number 8 of note. Okay, next, Mr. Cullen.
I wondered if Mr. Bayless or others could give us a bit of interpretation of that. I heard him read in the clause. Maybe rationale is what I'm looking for in terms of understanding this prior to our vote.
The rationale, you had mentioned mediation previously. The Information Commissioner has also indicated the importance of an explicit ability grounded in legislation to publish her orders, and it's incredibly important. We've talked about frivolous and vexatious. We've talked about some of the new language in the Act. All the more important that there's going to be a body of precedents that we're going to see built up publicly over time. We're not going to see the decisions appealed to court all of the time, so the body of jurisprudence built up by the Information Commissioner is all the more important.
And so, yeah, thank you for that. And so, only after the court review expires is the one condition you have. So there's a review period. Forgive me again for not being familiar with how the court system works at this point, but is there anything particular about that in the amendment?
Yeah.
Question answer, Mr. Erskine-Smith?
I mean, you're requiring that it be a 30-day waiting period, I think, and ensuring that the department isn't appealing. In most cases, we've heard, even under the current system, rarely do these things go to court. So I think you're going to find the Information Commissioner being, in most cases, the one who is publishing the order and making the determinations and findings. But in the rare case, it's not going to be published right away, and a court will make the law.
Any further debate? Okay, we'll get to the vote. All in favor of Liberal number 7? All opposed? Liberal 7 carries. NDP 26.
Yeah, essentially this is a recommendation that came from the Ethics Committee last time, as well as it did the Information Commissioner. So it'd be weird for us to say no to both ourselves and the Information Commissioner all in one shot. This is about the publisher findings as well. It's similar to what Mr. Erskine-Smith and Mr. Bayless just moved with respect to building up a certain amount of jurisprudence. And this, I think, not only just building it up for its own sake and making it public, but allowing departments to see what kind of rulings came out that would then guide their own actions as to where the boundaries may or may not be, as opposed to having to essentially litigate these things over and over again. So I think this is actually, I wouldn't say enhancement, not that Liberal 7 that we just went through is not enough, but this certainly is an extension of that by amending Clause 17 on page 42.
Further debate? All in favor of NDP number 26? All opposed? It is defeated. Shall Clause 17 carry as amended? All in favor? All opposed? Clause 17 carries. Shall Clause 18 carry? All in favor? All opposed? Clause 18 carries. NDP 27. I'm going to read the note before we get any further along. Identical to PV 12. PV 12 cannot be moved after a vote on NDP 27. Mr. Cullen.
Yeah, again, this is going back to that interpretation piece where we had some distance between what the Treasury Board president was saying, what the Information Commissioner was saying is the reality. NDP 27, 28, and 29 hang together because it allows for the oversight model that was recommended by the Information Commissioner and again by the Ethics Committee who studied this before. So if the government, the current government has claimed itself to be a government that's going to make policy based on evidence, this is the evidence before us in terms of allowing proper oversight when things essentially escalate. The Commissioner in her special report to this committee said, and I'll quote one more time, the Commissioner recommended adopting an order-making model where the Commissioner can issue an order disposing of the issues raised, with orders subject to judicial review by the federal court. The Minister, I think, attempted to say, oh, that's exactly what Bill C-58 does, but in fact doesn't do. If the Ethics Committee prior to us recommended this order-making power and made the recommendation very clear, if the Information Commissioner has also recommended that, that's the power that she needs to get information to Canadians, and evidence is supposed to be what is guiding us as a committee and this government, then we strongly feel that NDPs 27, 28, and 29, allowing for that to exist in the real world, is important. If it's not, I think we're sending forward a bill that is, at this point, becoming fatally flawed. I just don't see how the Commissioner can come before us and say, I don't have the proper powers to do my job sufficiently right now, that the previous committee studying this made this explicit recommendation, and that this committee says we somehow know better, because we don't. I think these things hang together properly and are based almost entirely on the experience of our Ethics Commissioner and the experience that the Ethics Committee had prior in studying this legislation.
Yeah, I can only say ditto. I mean, the logic is powerful.
I have Elizabeth May, then Mr. Erskine-Smith.
Thanks again, Mr. Chair. And of course, because when Mr. Cullen's motion is disposed of, as you said, then I won't be able to speak to this one. But very briefly, the difference between judicial review of the Commissioner's order and what C-58 presents, and why C-58's dealing with judicial review to having a review not of the Commissioner's order but of a government decision, is a regressive step, in the words of the Information Commissioner. As someone who used to practice law, the difference is really clear to me. Judicial review of an order means the record that was there when the Commissioner made a decision is the record that will be examined in the review. What's being proposed here is that the court will look at a situation de novo, which is clean slate, no record. It creates no incentive whatsoever for an institution that wants to hide information, delay release, to move forward. In fact, with a de novo hearing, they can stall, they can provide new information, new arguments. In other words, it's a significant regression over where we are now, and the point of this bill, I thought, was to improve the situation for access to information. So I do hope that the Commissioner's recommendations around the orders being reviewed will be given serious consideration by the government.
Mr. Erskine-Smith.
So I'm one of two members that was here when we made those recommendations. Certainly we did recommend an order-making model that would have a reasonableness standard. I would disagree with my colleague, Ms. May. This isn't a regression over the current system. The current system ensures that, or enables the Commissioner to take the department to court ultimately with the consent of the complainant. And it is an effective de novo process. There's not a reasonableness review. This is a similar de novo process, but it's an onus shift. So the onus is now on the department to take the Information Commissioner's decision to court. So I think it is an improvement. And the testimony we heard in the course of our committee study was actually from the Canadian Bar Association and from the Commissioner in Newfoundland that suggested this was a reasonable option, especially as a first step, and if it's inadequate, then adopt a reasonableness standard approach that is in other jurisdictions, including BC and Ontario. While I preferred the reasonableness standard, because for efficiency purposes, as a first step, I recognize that this de novo process is within a range of reasonable options, I think, and so I don't view it as a regression. I view it as a step forward, perhaps not as far of a step as our committee had recommended, but we certainly heard testimony that this was a reasonable option, and so it's certainly certainly not where I think, I don't think it's worth fighting this particular issue.
Mr. Cullen?
I guess the question becomes, why not, in a way? Why not fight for something that this committee has previously identified as better, that the Information Commissioner has said is better, than simply saying this might be a slight improvement to the side of a thing that has proven to be problematic over time? That it's a technique or a tool. There was some assurance given at one point, I think it was one of the government officials that said, well, departments aren't likely to go to court on this. That's no assurance at all, because they're not spending their money. I mean, this is taxpayer money to seek court. If there's information, particularly of the sensitive nature, Chair, which is generally the stuff that we're talking about as being important, of course government will seek remedy at court as a way to make a process that could be 3 months or 4 months last 3 years or 4 years. So I take no assurance from any notion of no department's likely to take the commissioner to court or the complainants. Like, of course they will, if that's a tool available. So to the question of, we're not looking to sacrifice the good as we aim for the perfect, and I don't think what we've offered here is some unattainable thing. So I put my question again to our Liberal colleagues, that if the evidence that the previous committee studying this put forward and recommended, including Liberals, if the Information Commissioner also put this testimony in front of us and there's no condemning action against it, there's nothing saying if you were to do this, this would cause harm to the Canadian public, then I don't understand how my Liberal colleagues are voting. I honestly don't, because you ran on this. This was about open and accountable government. We have open and accountable recommendations in front of us and the power to make this legislation significantly better. To not do it is to suggest that all of those were words, and that the reality for Canadians seeking information from government is that their reality is going to be made much worse at the end of this process, and that's unfortunate.
Mr. Erskine-Smith?
Just very briefly, I mean, to have testimony from the Canadian Bar Association and the Newfoundland Commissioner that this is a positive step forward, I think I think they're correct. I mean, this isn't a regression. We've put a suggestion and a recommendation to the government to, in the course of our committee report, the government consider it, also review the testimony of the Canadian Bar Association and the Newfoundland Commissioner. Frankly, the Privacy Commissioner as well, for those who, if you'd been here at the time, the Privacy Commissioner originally came to us and said a hybrid model is the best model, and he wasn't asking for, and so reasonable voices were pushing in this direction. One can reasonably disagree, but we are in a range of reasonable options here. And I would say once I've put a recommendation to the government and the government has considered it and opted for another reasonable option, I don't think ping pong makes sense at this point, and that's my view. Well, the government certainly was aware of our recommendations and aware of the testimony when they were making this decision.
Mr. Cullen?
But I'm unaware of any testimony that came from the bar or anybody else who said this was a bad idea. And I guess that's the point. Government may deem this unfavorable. They may dislike it. It may cause them other concerns, but those are not my concerns. Unless somebody comes to the committee and says this order-making power, this ability to give the commissioner this new power to get information from government is a bad thing. Until someone says that, then I say, well, we should base our testimony on the best that we have available. And sure, some witnesses said maybe one step down, maybe a hybrid is better. But this was told to us, and this is what this committee previously recommended. There has been no significant evidence, again, an evidence-based government I'm supposed to be looking at, that said this would be harmful. Until I hear that, then I don't know how in good conscience the committee can recommend something that we have been told is good, have been offered a slightly watered-down version. Why not go for the one that's the best on offer? We can always improve, I think the Prime Minister said. Here's an opportunity.
Mr. Kent?
Let's take him at his word.
Yes, and just very briefly, if this was the only advice or recommendation of the committee or the commissioner that's been ignored by the government, we'd be in quite a different place.
That's right. There's a pattern we're concerned with. That's complete.
Any further debate? We'll call the vote. All in favor of NDP recorded vote?
Yeah, this is where it goes to die.
Sur la motion du NPD numéro 27, Mr. Bayliss.
Against.
Mr. Dubois. Mr. Erskine-Smith.
No.
Madame Fortier.
No.
Monsieur Picard.
No.
Mr. Saini.
No.
Mr. Gourde.
Oui.
Mr. Kent.
Yes.
Mr. Cullen.
Yes.
So NDP 27 and PV 12 are defeated. On to NDP 28. So I'll just, another note here. This vote will apply to consequential amendment NDP number 31, just as a note to the committee. Mr. Cullen.
Well, as I said when we were talking about the previous article, Chair, these three, 28 and, sorry, 27, 28, and 29 hang together. You can sense my consternation. Yet, it's not my first rodeo. With no offense to the previous members of the previous government, this is Groundhog Day again, where the committee goes through the process of inviting witnesses. We hear their testimony. We make recommendations based on their testimony. In lockstep, the government just votes them all down one by one by one. Not entirely, with some occasional caveats, if I could put it that way, but clearly with some. And I guess at this point I would say to my colleagues, with the caveat that was just mentioned, some rationale as to why we're voting against these things as the government would be really helpful for my understanding of where the government's actually headed on access to information, because this was a central part of the conversation leading to your election. And so if we're going to vote against these things, as the government does in lockstep nearly all the time, saying why would be, indulge me, I suppose, indulge Canadians who are wondering what happened to the promise and principle. So we can go through the process on both, Chair, but the notion of these things, again, is based on the Information Commissioner's testimony, is based on the Ethics Committee's report, and I'll not apologize to my Liberal colleagues if this seems repetitious, but if we're not going to base our recommendations on evidence, then what are we basing them on? Because instructions from the PMO don't count. What we should be basing our efforts on here is what we heard at the table. Otherwise, this entire thing was a bad faith process and a sham with some other intention in place. So I'll move my amendment and with support, and if someone from the government benches wants to tell me why it's such a terrible idea, I'd love to hear it.
Looks like Mr. Erskine-Smith is ready to answer your question.
You mentioned evidence, but on this point in particular, we heard evidence from the Information Commissioner and evidence from the Privacy Commissioner, and it was different evidence. They were of a directly contrary view on the point in relation to this particular clause that you're moving. So, or a motion that you're moving. So, you can disagree with the Privacy Commissioner. The government can disagree with the Information Commissioner on this point, but to suggest that this is an absence of evidence, this is just a disagreement between two commissioners.
So if I could, this is a good point, because in the Information Commissioner's testimony, as we attempted to do, and I believe some Liberal colleagues did as well, in her recommendations, we asked for experience. At what points were access to information requests frustrated, and how would your recommendation resolve that? We had no similar experience and testimony from the Privacy Commissioner. We had an opinion that was offered that said, I like this other process, but we didn't have any ground truthing of the experience. So if I have two commissioners, and this sometimes happens because there's a natural tension that we experience between the Access to Information Commissioner, who wants as much information as is proper out there in the public, and the Privacy Commissioner, who's generally charged with keeping things private. That's a normal and natural tension. But one watchdog came forward and said, this is how this would improve the experience of gaining access to information, holding government to account, having evidence-based decision-making. I take that, actually, for greater value than somebody who comes in with anecdote and opinion. As much as I respect the Privacy Commissioner and value his work, I asked for real world. And I got it from one commissioner, and I didn't get it from the other, so I'm going to side with the one who was able to ground truth anything that came before us. And so it's with that deferential respect that we chose one over the other. And I think that's commonsensical from where I come from. That just kind of makes sense, but maybe other people have different life experiences.
Mr. Erskine-Smith?
No.
Okay, so we'll call the vote on NDP 28. Unless there's any further debate. I just heard somebody. No, we're good. All in favor of NDP 28? All opposed? NDP 28's defeated. Shall clause 19 carry? All in favor? All opposed? Clause 19 carries. Shall Clause 20 carry? All in favor? All opposed? Clause 20 carries. And we're moved to NDP number 29. Again, another note, identical to PV 13. PV 13 cannot be moved after a vote on NDP 29. So I'm assuming Mr. May would like to speak as well, but I'll give the floor first of all to the NDP.
Thank you, Chair. And this, of course, because these three amendments, improvements to the bill, excuse me, hang together, work together. I realize I'm not going to necessarily have the satisfaction of understanding why colleagues are voting against it, with a small caveat. The intention remains to give the Information Commissioner the power that she needs in this case to get the information that we need as policymakers to make decisions. And I would again refer my colleagues to some of the legislation just recently introduced around violence against women, which was entirely achieved under access to information, which under C-58 could have been deemed frivolous requests from Ms. Doolittle at the Globe and Mail. That the reason that the National Inquiry into Murdered and Missing Aboriginal Women actually has a figure as to how many murdered and missing women have disappeared in this country was also done only through access to information, which this bill would also threaten the release of that information. The transfer of Afghan detainees, things that matter. I know that this is not a piece of legislation, Chair, that we have a natural and many constituencies to, yet all constituencies are affected by the ability to get information from government, because that's the only way you can hold government to account. Otherwise, it's anecdote and conjecture. So I won't re-emphasize the point about the court order-making powers that was established in my previous arguments and turn it over to Ms. May.
Thank you. And the amendment is identical, and that is because, like Mr. Cullen, I'm very persuaded by the evidence of failing to strike the right balance for transparency, the recommendations of the Information Commissioner. These do hang together. They're found in her recommendations 18, 19, and 20. And this amendment actually speaks to the amendment, the suggestion she made that's labeled Recommendation 18, that when we look at the actual precision of underscoring that for greater certainty this application is de novo, is a new proceeding. That is, it goes to the heart of where she finds the problem in moving from the model we have now to a new model, which she has labeled the result of what's being proposed in C-58 is a regression. So in an effort to try to improve the legislation, and I think I'm really so impressed with the work the Information Commissioner did on so many points, as Mr. Kent has mentioned, on so many points, she finds that this act, which was supposed to be improving our access to information in Canada, is actually going in the opposite direction. So I can see which way this is going to go, but I appreciate the chance to speak to it, Mr. Chair, and I would urge that the committee support it deleting the clarity that insists this is de novo review.
Mr. Erskine-Smith, in response? Okay. We'll call the vote. All in favor of NDP 29 and PV 13? All opposed? NDP 29 and 13 are defeated. PV 13 are defeated. Shall Clause 21 carry? All in favor? All opposed? Clause 21 carries. Shall Clause 22 carry? All in favor? All opposed? Clause 22 carries. Shall Clause 23 carry? All in favor? All opposed? Clause 23 carries. NDP 30, once again, as a note, identical to PV 14. PV 14 cannot be moved after a vote on NDP 30. So again, we'll start off with Mr. Cullen and then to Ms. May.
I may have a bit of a misunderstanding. It might take a moment if we could suspend this piece, Chair, because my understanding was that if PV 8 fails, which I believe it did, then this was paired with it. So while maybe not being identical, it wasn't my expectation as PV 8 had failed, unless the clerk will correct me that it did not.
I will just check with the clerk now.
Yeah, you want to just take a moment? That would be helpful.
Yeah, we don't see that conflict, Mr. Cullen, so with advice from the legal clerk.
Yeah, my understanding in checking with Crystal is that the two pieces hung together, and I'm not sure, without a bit more of a review of the one amendment without the other, whether it would even be sensible to move this one. So I don't know about procedurally, but I would likely seek to.
Well,
I don't wanna
there's,
do damage.
Ms. May can also speak to this, so
Okay.
we can either proceed on either ground, so.
So why don't we allow that? Because my initial instinct is if the two hang together, then I'm not sure if this one moving on its own would be a good idea or not.
For the record, the clerk doesn't see it that way, so just
Yeah, yeah.
for the record.
No, it's the way legislation works.
Go ahead, Ms. May.
Well, the purpose of the amendment that I'm proposing, which I guess is identical to, which NDP motion is PV 14 identical to?
30.
Okay, I'm on two different agendas, so I apologize. The purpose of this amendment, again, is based on recommendations from the Information Commissioner to amend these sections to reflect that it is the Commissioner's order that is under review before the federal court, as opposed to the government's decision, which is under review. So again, it's the deletions it's deletions, but replacing lines 5 to 7, so that the record is on the government institution concerned, as opposed to the current language, which is the decision or take action that is subject of the proceedings is on the government information concerned. The effect of that is to ensure that it's the Commissioner's order that's under review.
Any debate on that?
If I may,
Yes.
I'm not comfortable with this because while the clerk's got one interpretation, we have advice another way, and in that sort of battle of interpretations on this, I'm going to withdraw it rather
Okay.
than
That's fair. You can do
seek
that.
something that I'm not confident in.
You can do that, Mr. Cullen. So in that case, we're voting on,
I'd just as soon have a vote on PV 14, even though I can't vote.
What should I vote?
yeah, just consulting with the legal clerk, it would need unanimous consent to be withdrawn before committee. So do we have unanimous consent to withdraw? Unanimous consent? Looks like we do. So it's been withdrawn. So now we will go forward and vote on PV 14. All in favor? All opposed? PV 14 fails. So now we go on to NDP number 31.
It's been dealt with.
Oh, sorry, hold on.
It's been dealt with. So we do.
So that means. Yeah, my apologies. It's already been dealt with under NDP 28, so we'll move on.
31 has been dealt with?
Yes, under NDP 28.
Can I just have one moment?
Sure.
You're saying 28 dealt with, is too similar
31.
to 31?
That's what we're saying.
I don't know if it's appropriate, Chair, but I see that different. Could we have some interpretation of that? This is about the onus and where the burden goes in terms of getting a judicial review.
Yeah,
I was-
we'll just give the clerk a
Yeah,
minute
you
just
bet.
to
You
prepare what he's going to say.
While you're figuring that out, can we, assuming this is defeated, can we start, like, where, just for efficiency, doing it in blocks where there aren't amendments?
That would be an assumption that I would not make, that it would be defeated, but we can certainly, once this is voted on, that we can vote in blocks. Depends on what the room wants to do, but as chair, certainly I would entertain that.
A ton after this. Do you have a lot more? Oh, no, man. Serious consideration of legislation is the job. True. Being legislators and all. Tea time?
Well, right?
Oh, if there's no
That's what I'm
amendments.
saying, yeah. We'll vote on block in between where there are no amendments. That was
Oh,
my
I see.
point.
Sometimes it's tricky to do if there's
guess this one can.
Yeah, just some clarity. It's, we can proceed. I can explain it actually well. Yeah, go ahead.
I saw a relationship between the two, and my idea was that if NDP 28 was to be adopted, then 31 would be adopted as well. But I think since NDP 28 has been rejected, NDP 31 could live by itself. So I think it would. It could.
Yeah, because that was our question.
Exist independently.
It's where the burden of judicial review falls, right? Yeah. Does it fall on the person making the request, or does it fall on the institution denying the request, or having a conflict with the request?
We can ask legal advice at that end if you wish, Mr. Cullen.
Sure.
But now we'll.
Legal advice.
It's back on the floor. NDP 31.
Yeah, I'm certainly happy if council has any advice on this. But our understanding was this on 31 was a simple. Or no, you can call it simple or not, but it's shifting a burden about seeking judicial review, whether it was on the institutions itself and as we're seeking it to be, not on the requester themselves, which is a burden on the Canadian who's trying to seek the information from government. I wasn't made aware of any testimony that said that would be a legal problem. This would be it's an onus question. Where do we want to put the onus and the burden on? And we thought it was appropriate with the institution denying the information, as opposed to the person seeking it.
Who would you like Mr. Cullen to respond to that?
Well, no one's looking at. I don't know if anyone has any advice or interpretation, Ms. Naylor.
Bill C-58 presently puts the burden on the government institution, so that's what the bill does now.
But we saw section clause 24 as not allowing that, and that the amendment that we sought to make would clarify that. Are you reading it differently?
We're taking a look at it.
Okay. Because if that's what the C-58 overarchingly seeks to do, then this is what our attempt and amendment clarifies, unless we've got the amendment wrong, which sometimes happens.
Just for the sake of the committee, I'm just going to suspend. So if somebody needs to use the washroom or get a coffee, you can feel free to do so for 2 minutes while you suspending. Call the meeting back to order. So we'll ask Ms. Naylor if you had a chance to sort things out. Okay, please proceed. Order.
So our understanding of the effect of this amendment would be to delete a reference to the Privacy Commissioner's right of review in the section that describes burdens of proof in relation to the Privacy Commissioner or third parties' rights of review. So it's related to the previous discussion around NDP 28, which would have removed the Privacy Commissioner's right of review. This would be consequential to that, remove a subsequent reference to the right of review, if that had been deleted. Is that clear?
Mr. Cullen?
Yeah, so just to clarify, Ms. Naylor, you're suggesting that this is a piece that hangs with the other section in terms of right of review, just in its application to the Privacy Commissioner.
That's correct. It makes sure that if the previous amendment had been approved,
Right.
supported, that the appropriate consequential amendment would have been made as well.
Thank you for the clarification. Thank you, Chair. We can go, unless there's comments, we
Any
can go to
further
vote.
comments or debate? So shall NDP 31 pass? All in favor? All opposed? NDP 31 fails. Shall Clause 24 carry? All in favor? All opposed? Clause 24 carries. Now we have an opportunity to, there's no amendments from 25 to 30. We can do these in blocks if you wish. Okay, so we'll do it. Okay, so in order to block them, again, this isn't our first rodeo. We need unanimous consent to block them. 25 to 30. Do I have it? We do? Sure, why not? Go big or go home, right? Okay, so it looks like we have unanimous consent. So all in favor of clauses 25 to 30? All in favor? All opposed? Clauses 25 to 30 carry. Oh, good. Okay, so we have Liberal number 8. Dealt with under Liberal number 7. And we have Liberal 8.1. Mr. Erskine-Smith. Mr. Picard.
Understanding that this was a consequential of Liberal 7, so therefore, if Liberal 7 was accepted, then this one...
That was in reference to 8, the one that I just mentioned. This is 8.1.
Oh, are you at for the new clause at 30.1?
8 point... Yes, you're right.
31.
Okay.
Clarity though, so Lib 8 creates clause 30.1, as I understood it, and then we didn't approve clause 30.1, or it just...
With Lib 7.
Oh, it just, okay, it assumes to be approved as a clause?
Yes.
Okay, so now we're on clause 31, all right.
Yes.
Okay, so okay,
go ahead.
So I'll do something for the floor.
Yeah.
Point one, thank you.
Yep.
Donc, cet amendement, en fait, vient éclairer une question de confidentialité où...
This amendment clarifies the question of confidentiality then. A legitimate request cannot be refused, but if it is a public request, information is asked to support this public inquiry. This helps to obtain authorization for the disclosure, provided that it is already public.
Just to be clear, I just want to confirm that we're on Liberal 8.1.
8.1.
Yes.
Une modification.
Clause 31.
Modification de l'article 131, oui.
Okay. Okay, Mr. Cullen.
Yeah, I'm just again asking. I heard the argument, haven't heard the rationale. Was this based on testimony where information was given over to the public in an inappropriate way? Because I guess I'm looking back to 8 and seeing some of the rationale in your amendment. And forgive me, Chair, these are connected, and I'll bounce a little bit, but that the Information Commissioner and any person acting on behalf or under the direction of the Information Commissioner shall take every reasonable precaution to avoid the disclosure of and shall not disclose. Was there some, I'm just trying to recall, was there some complaint?
L'exemple que je préfère.
The example that I could provide my colleague with, if there's information that is public, proactively disclosed, and there may be some doubt in the mind of the reader, and ask for information in support of this. And in such cases, there can be a refusal because the information was public. There's a certain format that has to be respected. If there is any doubt then about what the basis of this information proactively disclosed is, then this information becomes accessible through a request. Yes, but there was a particular incident. Was there a case raised in a testimony about information that was not made available?
There isn't one, that's fine. If it's just a precaution. My curiosity was, has this happened, and is this a concern, and why are we putting it into legislation if we don't have any experience with it?
Would you like to respond, Mr.
Non,
President?
non, c'était une des préoccupations qui avait été soulevée par le commissaire.
This was a particular concern raised by the Commissioner.
Any further debate? Seeing none, all in favor of Liberal 8.1? All opposed? Liberal 8.1 carries. Shall Clause 31 carry as amended? All in favor? All opposed? It carries. Shall Clause 32 carry? All in favor? I just need to see hands, folks. All in favor? All opposed? I know. It's a lot of work to raise that hand. I know. It's a long day. Wednesdays are long days. Okay, shall Clause 33 carry? All in favor? All opposed? Clause 33 carries. Okay, so we have shall Clause 34 carry? All in favor? All opposed? Clause 34 carries. Shall Clause 35 carry? All in favor? All opposed? Sorry, it's funny watching you try to raise your hands. It's not that hard. Sorry. Okay, shall Clause 36 carry? All in favor? All opposed? Clause 36 carries. I just need some kind of signal, that's all. Yeah, please no fingers. Okay, we have PB 15.
Thank you, Mr. Chair. Again, this is advice from the Information Commissioner, and I do want to say I think the practice the Prime Minister has adopted of publishing mandate letters is really a really positive step forward. I'll note that it was without any legislation required. It set a good example, and the new Premier of British Columbia, John Horgan, published all the mandate letters. It begins to catch on as a practice, and that's great. So I'm glad to see it legislated here, that we will continue to see that from future Prime Ministers. The Information Commissioner noted that there's no time limit attached to this, and that might be a good idea. So my amendment here, and I do appreciate the gender neutrality with which we refer to a Prime Minister, whether he or she establishes the mandate of any other minister within 30 days after the issuance of the letter. I think it's quite likely that in the normal course of things, with a requirement like this, a Prime Minister would make the mandate letter public, but there's nothing that would cause the Prime Minister under this legislation, imagining a future Prime Minister who didn't want to publish a mandate letter, to do so when there's no time limit. Thank you.
Thank you, Ms. May. Another note, if adopted, NDP 33 cannot be moved as a line conflict. Mr. Cullen.
Too bad, because, you know, NDP or Greens in a hurry. We wanted to do it in 15 days, but, 30 or 15. I thought we could have moved a friendly amendment to suggest that they also have to follow their mandate letters, but, that's maybe too much to ask in one piece of legislation, so maybe next time around.
Outside the scope.
Outside the scope. You can publish it, but you don't have to do it, or you can change it with a new mandate letter. It's a good trick. This is clearly that if you had this prime minister or a future prime minister issue a mandate letter that had no time on it, you could simply never publish it. And so why not put a date on it? And 30 days, well, it's a little long. This is reasonable. So we'll support this.
Okay, any further debate on PV 15? Seeing none, all in favor of PV 15? Opposed?
Now I'm all messed up. Because 15 on principle. It was the part NDP that stopped you right there.
Sorry,
that can't happen.
Can I just see a show of hands just to confirm that all in favor?
Yes, a green amendment has passed.
All opposed?
Done.
Okay,
Thank
good.
you.
Just wanted to confirm. Yes, thank you.
Last,
So PV 15 carries. NDP 33 as a result cannot be moved. Liberal number 9, Mr. Erskine Smith, or whoever your designate is.
Mr. DeBoer.
Mr. DeBoer.
This is an amendment that corrects a drafting mistake in the original. That is why we want to have it changed. If it is a fourth quarter, and therefore that is the gist of the amendment.
Sorry, to be clear, we're on 9.1 or we're on 9?
We're on 9.
Okay, so similar request to last time. Just curious for rationale. We try to bring. I can read the amendment, but just the rationale for it, and if it was based on any testimony, what testimony that was.
It's not necessarily testimony, as you said, but it is the way in this particular section was drafted. It said within 30 days following, depending on the quarter in which the amendment was made. Therefore, what is being clarified here is that 60 days, within 60 days, according if it is the fourth quarter. You understand then that if we are in the fourth quarter, then my understanding is that in the case of the fourth quarter, this is being added.
With respect, Mr. Dubourg, we're still on 9. I think you're speaking to 9.1.
Yeah, we're on 9. Yes, exactly.
Okay.
9.1 deals with the quatrième semestre and all those things, but
9. What is 9?
9.
Exactly. Yeah.
Okay, that's fine. Thank you, Mr. Dubourg.
Thank you.
Any further
It's a drafting error.
debate?
Yeah.
Seeing none, all in favor of Liberal 9? All opposed? Liberal 9 carries. Liberal 9.1. Who would like to speak to that?
Sorry?
Who would like to speak to 9.1?
Yes, please. Can I have
Mr. Cart?
45 seconds suspension just to clarify a...
Yeah, can do that. Just suspend for 45 seconds.
In fact, c'est pour corriger une erreur dans la...
It is to correct a mistake in these particular provisions and the way they're enumerated 1, 2, and 3. They should be appropriately aligned.
Thank you, Mr. Dubourg. Any comments, debate? Seeing none, all in favor of 9.1? All opposed? 9.1 carries. So we have PB 16, another note as well, identical to Liberal number 10. Liberal 10 cannot be moved after a vote on PB 16. Ms. May.
Yes, thank you, Mr. Chair. This is again based on recommendations from the Information Commissioner. And I just want to read from her text because I think I've looked back and found, I think this one sentence distills very clearly why this amendment is being made. This is quoting, proactive disclosure requirements where the government chooses what is disclosed are not the same as subjecting these entities to the right of access, where requesters can choose what is requested and are entitled to independent oversight of government's decision on the disclosure of information. So what I am proposing to delete here, which I gather is identical to another motion to delete. The purpose of this deletion is to remove what's found at Section 91 that removes from the Information Commissioner any jurisdiction over those identified pieces of information such as spending limits and grants and contributions and briefing materials and so on, for which the government under C-58 is proposing that they will automatically disclose, but not allow the Information Commissioner to check on what they're doing. This provision and my deletion would allow the Information Commissioner to have oversight over the proactive disclosure requirements that the government's bringing forward. I see no harm in it. I certainly hope that I'm on a roll. I would hope I'm on a roll here. There it is. Thank you.
Mr. Cullen.
Dare to dream. I think it's good. I hope you are too, simply because if the government, which made, the ministers that appeared made importance of the proactive disclosure piece of the efforts, simply allowing the Information Commissioner access to those similar files shouldn't be a problem because they're all meant to be public anyways. Information Commissioner asked for this. I think it's certainly reasonable to grant it to her and to future commissioners.
Any further debate on PB 16? Seeing none, all in favor of PB 16? All opposed? PB 16 is defeated.
Don't go to the casino just yet.
And as we'll move on to Liberal 10.1. Who's your spokesperson, Mr. Erskine-Smith?
C'est moi.
Ms. Fortier.
Alors, je voudrais proposer.
I'd like to move this amendment in view of the fact that we did hear concerns raised in relation to this particular part of the bill. It's part of a number of amendments then that are being presented by our party. I would like to propose then that this amendment be adopted.
Okay. Any debate? Mr. Cullen?
Just a moment to, I don't want to keep asking the same question again, but I'm wondering, I heard the put forward, but not necessarily a particular reason why, and if there was testimony we could reference, it helps me understand whether I should be voting for or against. So why this, and based upon?
C'est encore en revenant.
Once again, it is in relation to the proposals made by the Commissioner. We thought that it was the right thing then to present this submission in response to the Commissioner.
Some of the things she recommended we take, and some of the things we don't, but that's okay. Thank you for that explanation.
Any further debate? All in favor of 10.1? All opposed? 10.1 is carried. Shall clause 37 carry as amended? As amended. All in favor? All opposed? Clause 37 carries. Liberal 10.2. Who would like to speak to that? Mr. Bayless.
So we heard testimony from the judiciary about the concern they had with respect to having some of their expenses made accessible. And they had suggested some changes wherein, instead of having it judge by judge, that we could aggregate it all. That sounded like a good suggestion to me when I heard them. And then when we had the Information Commissioner come in, she corroborated that she agreed with that concept, that it was the right balance to be struck. So 10.2, followed by 10.3 and 10.4 are in line with that change, with that suggestion from the judiciary.
Mr. Cullen?
Just so I have it right, through you to Mr. Bayless, this amendment would essentially compile the information and the spending rather than delineate line by line, hotel by hotel, out of concerns over safety, essentially. I mean, that's what part of the...
It's by court rather than by judge.
Oh, I see. So I guess I'm trying to understand what the impact of
It would be
this
line itemed, but just not assigned.
line itemed by the court rather than by the judge, so it wouldn't be, because the Information Commissioner also, she actually, I think, had suggested something where it was given as a more broad figure rather than detailing
An
specific.
aggregated figure, that's
So
correct.
this would still allow for the publication of that spending. It would detail out hotel bills, restaurant bills, et cetera, but by court rather than by the individual judge.
Yes. So it's the finding and balance that's what the judges had suggested, and that is the Information Commissioner, she agreed with that in her last testimony.
So no more Trump Towers is what you're saying when they're traveling abroad. Too bad.
You'll have to ask the judges about that.
Well, we'll find out, won't we, though? Who stayed at the Trump Towers?
Okay.
I don't know if you can aggregate 10.2, 3, and 4 because they go together as one objective.
We need unanimous consent again to do that? Do we have unanimous consent to block 10.2, 10.3, and 10.4? I just am not seeing 10.4. Just let me find
Yeah,
it.
it's just been circulated. It was right there.
Okay.
Okay, yeah.
Yeah, so do we have unanimous consent?
Just one second.
Or if we're going to clump them? Have we agreed to clump them?
That's, I think we were waiting for you to read it and
Yeah,
then whether we have
can
unanimous
clump 'em.
consent.
If I can just ask a question.
So do we
about
have
10.4?
unanimous consent to block them? Yes. Mr. Cullen?
So just on 10.4 then, these carve-out provisions for Prince Edward Island, Yukon, Northwest Territories, and Nunavut. A particular reason for this is just that how the courts are so small is the assumption that I want to make, so that the entire jurisdiction is then clumped together.
Yeah, so the north would be clumped as one, and then with respect to Prince Edward Island, the Court of Appeal and the Superior Court. Just
because if it were not,
the numbers are too few, exactly.
okay.
So, okay, so any further debate? All in favor of Liberal 10.2, 10.3, and 10.4? All in favor? Hands, please. All opposed?
Opposed?
I saw 2 in favor, 5 against.
Maybe, can we just have a clear show of hands? My apologies. I've seen some hands. All in favor? All opposed?
That's 2-5.
Yeah, so that fails.
So, the 11.
Okay, so we'll move on to Liberal 11. Who's speaking to Liberal 11? Mr. Erskine-Smith.
Yeah, so I'm not going to move Liberal 12. I'm just going to stick with this. We heard testimony from the Justice Association in relation to judicial independence and just who should be the final arbiter of judicial independence, and that it should lie with the Chief Justice of the affected court and not with a member of the executive. And I think that's correct. So I'm putting this forward.
Any further debate on Liberal 11? Seeing none, all in favor of Liberal 11? All in favor? All opposed? Liberal 11 fails.
That was my worst effort so far.
Liberal 12 has been pulled back. Shall Clause 38 carry? Mr. Erskine-Smith just retracted it.
Oh, you did?
Yeah.
Liberal 11 was the stronger version of that.
Understood.
Okay.
But presumably, I was the only vote for Liberal 12 as well.
Don't assume.
Shall Clause 38 carry? All in favor? All opposed? Clause 38 carries. Okay, there are no amendments from 39 to...
No, because
So-
that one arrived later.
Okay, shall Clause 39 carry? All opposed? It carries. Shall Clause 40 carry? All in favor? All opposed? Clause 40 carries. Liberal 12.1.
So, yes. I would
Ms.
like
Portier.
to move the bill, the clause 41 be amended by deleting line 26 on page 48, please.
Okay. Debate? Mr. Cullen?
I may have missed this one. Was this dropped recently as well? And I guess my question, because it's very straightforward, is what does that amendment do before we have a vote?
Go ahead, Ms. Fortune.
So this is a consequential amendment related to the new section 11.1. The new section 11.1 makes clause 41(5) redundant, as the phrase "this act" has now already been replaced by the phrase "this part" in section 26 of the act.
Very good. Thank you.
Thank you.
Any further debate on 12.1? Seeing none, all in favor of 12.1? All opposed? 12.1 carries. Shall Clause 41 carry, as amended? All in favor? All opposed? Clause 41 carries. Clause 42. All in favor? All opposed? Clause 42 carries. Shall Clause 43 carry? All in favor? All opposed? Clause 43 carries. Liberal 13. Mr. Erskine-Smith.
So this was a recommendation from the Information Commissioner, and we had a fairly lengthy discussion here a little while ago about reasonableness and different standards. While there is an important onus shift that is happening with the new order-making power, frankly, I do think it's important, and it should be in the purview of, I think, the Information Commissioner to administer complaints as efficiently as possible. And I think in doing so, there shouldn't be a dual-track system here where some complaints are not subject to the new order-making power and new complaints are. I don't think there is a downside, particularly in ensuring that she can use one model for all complaints that she's currently dealing with. And that's the rationale.
Any debate? Seeing none, all in favor of 13? All in favor? All opposed?
That's better than my last one. Better than my last one.
Liberal 13 fails. Shall Clause 44 carry? All in favor? All opposed? Clause 44 carries. Liberal 14.
I'm not moving it. It's the same as the last one.
Okay.
Pointless.
Okay, so you're pulling it back?
Yeah.
Okay. Shall Clause 45 carry? All in favor, all opposed? Carries. Shall Clause 46 carry? All in favor, all opposed? Clause 46 carries. Shall 47 carry? All in favor, all opposed? Clause 47 carries. Liberal number 15.
Yes, thank you, Chair.
Mr. Picard.
L'article 47 a mis...
There's the definition of the ministerial staff. This is a technical definition that provides that the effects will not be retroactive people referred to in the ministerial advisor then would not be affected by the new effects of the bill. It has a proactive effect then.
Thank you, Mr. Picard. All in favor of Liberal 15? All in favor? All opposed? Liberal 15 carries.
So we can go from 48 to 50.
Okay, so we're going to go, if I receive unanimous consent, to go from 48 to 52 as a block. Do I have unanimous consent to vote as a block? Yes. Do I have that? 48 to 52.
It was dealt with, they were dealt with.
They were dealt with under previous amendments.
Oh.
Like PB 17?
So dealt with under PB 8 is 17, and NDP 35 is dealt with under NDP 21, as noted previously.
MPB. So you're going up to 53, you said?
48 to 52.
52.
Yeah,
Okay.
so up to 53.
Yeah, that's fine.
Okay, so all in favor of bill or of clauses 48 to 52? All in favor? All opposed? Clauses 48 to 52 have carried.
In fact, under 53, it's dealt with.
So I'm seeking another unanimous consent motion as well to carry as a block clauses 53 to 63 as a block. Do I have unanimous consent to do that? Okay. All in favor of clauses 53 to 63? All in favor? Opposed? Clauses 53 to 63 carry. Okay, wow, look at that. So NDP 37 was also dealt with in NDP 8, so well, we can almost celebrate. Shall the title carry? All in favor? All opposed? Carries. Shall the bill... Sorry? Shall the bill carry as amended? All in favor? All opposed? Recorded division?
Recorded vote?
Recorded vote, sorry. Yeah.
Recorded division? Sure. You want to...
I'll get it.
Could have other consequences.
Yes, go ahead.
Sur l'adoption du projet de loi tel qu'amendé, Mr. Bayless.
Yes.
Monsieur Dubourg.
Wait, for clarity, this is, shall the bill carry as amended?
Mr. Erskine-Smith.
Yes.
Madame Fortier.
Oui.
Monsieur Picard. And Mr. Staney.
Oui.
Monsieur Gourde. Mr. Kent.
No.
And Mr. Collin.
No.
So the bill carries as amended. Shall I report the bill as amended to the House? All in favor?
I was going to ask that as soon as possible, yes.
As soon as possible?
Please.
Okay.
At the earliest
All in favor?
opportunity.
All opposed? That's a yes. Shall the committee order a reprint of the bill? Yes or no? All in favor? Okay. Well, thank you, everybody, for moving along. Looked like we were going a little slow there for a while, but thank you for all your input and your feedback, and all those who are watching out there. The meeting stands adjourned.